Good evening, everyone. Welcome to the Trenton Alumni Chapter of Delta Sigma Theta Sorority Incorporated's third session of our Get Your House in Order speaker series. My name is Nicole Carmichael, and I am the chairperson of our Economic Development Committee. Tonight, we are collaborating with the Zeta Iota Lambda chapter of Alpha Phi Alpha Fraternity Incorporated to bring you this valuable and pertinent session. In order to build a home, the foundation must be laid, and bricks are usually used in the initial stages. Tonight's brick focuses on wills and estates. We hope that you leave tonight's forum with valuable information about wills and estates. All of us are a house in progress. Soror Janelle Hazel is the committee's co-chair and will introduce tonight's presenter. Thank you. Soror Hazel.
Thank you, Nicole. Chandra Bettner Gray is a graduate of Rutgers University. She attended Seton Hall School of Law and ultimately received her Juris Doctor from Rutgers School of Law in Camden, New Jersey. Ms. Bettner Gray is the owner and managing attorney of Bettner Gray Law Office, where her primary areas of practice are real estate, landlord-tenant, estate planning, and probate. Chandra is currently an adjunct professor at Rowan at Burlington County and sits on the RCBC Paralegal Program Advisory Board. Additionally, she is a real estate continuing education instructor, broker, and the owner of the Legacy Realty located in Mount Holly, New Jersey. Finally, she is a licensed minister, wife, and mother who is committed to lifelong learning and establishing legacy by engaging, educating, and empowering the people she serves. We're so excited about your session tonight. Welcome.
Thank you so much. Oh my goodness, I am just so grateful and honored that you guys selected me to talk about this foundational issue or series of issues. One of those topics that we need to talk about, but we don't always love to talk about. But it is, in fact, something I'm quite passionate about for a series of reasons. The first of which is because when I was really young, I lost my mother, who was also really young, 39 years old, to Hodgkin's lymphoma. And so what that meant for me was that early in life, I crashed against death, and it's been something that's always been in the forefront of my mind, something I've had to live with. And though something very traumatic at the time for me, and something that I still dread, but it's something that I also recognize is a certain thing, right? So there are some things that we plan for or make provisions for in case it happens. And then there's this thing that we know it will. So I'm going to try to share my screen. I have a little presentation here. All right, bear with me, you guys. All right. Okay, so let's talk about estate planning. I used to do these seminars and talk only about the estate planning part and what documents you need. What do we even mean when we're talking about estate planning? And we are going to get to that, but I definitely think that we need to talk about some reasons why we need to do it before we get to what it actually is. Okay, so the first thing is we like to say this all the time, but it really means something. If you fail to plan, if you say, you know what, I'll do it later, or I'm not even going to do it, or I'm not even going to think about it, you're actually putting a plan in order anyway for failure, or to make things more difficult for your loved ones when you're no longer here, or even while you're here, but for some reason, if you are incapacitated or not able to do what you've always been able to do, but you didn't have a plan in place, you make things much more difficult. Now, we've already talked about one or some of the reasons why folks might die without a will, right? Because, and here this percentage, which actually may be higher, especially in the African-American community, a lot of folks, 60% or more, die without wills. This is known as dying intestate. And I have these questions here. Obviously, you can't engage with me, but surely one of the reasons is because somehow I believe we think that by having this discussion about our mortality that it may advance our death. It's just uncomfortable, and we don't want to talk about it, and we kind of want to believe that out of sight, out of mind, we're not, it's not, if we don't think about it, it won't happen. Okay, but we know that's not true. So we want to plan, because we say with our mouth, that we love those people who God has given to us, or who is in our life, whether that's our spouses or children, siblings, parents, whomever is our community, right? But this planning really is an act of love, right? Love is not just something we talk about, but it is something we live out. Also, and this is what we're about to get to, it really helps when we make these plans in advance to avoid breakdown, family breakdown. I know with all the folks that are on here, and I know more will be coming on, you have either experienced or have heard of some family breakdown that occurs around the death of someone in their family or a loved one. Brothers and sisters falling apart, cousins falling apart, step parents and stepchildren. These are things that will occur if there's no clear plan and order, right? And there may already be weird dynamics and relationships between the different folks. And so if there's nothing in writing and no clear provisions made, you can be assured that those things are just going to be inflamed. And then we add to that, the emotions and the grief. It can really just cause a whole lot of problems. Okay. All right. So, and then again, in the event of mental or physical incapacity, I was going to go to the next slide, but I want to mention that we don't anticipate that anything would occur in our lives that would cause us to physically be here, but to not be at our best, or to not be have all of our mental faculties or physical abilities, right? But the truth of the matter is sometimes those things happen, and they don't only happen just because of an accident or things like that. Sometimes it just happens, and sometimes it's genetic, and sometimes there's quick mental change in mental status, and we don't know whether that's going to happen or not. And so having some of these documents in place while you have everything together is a wonderful way of protecting yourself and your loved ones if and when something like that were to occur. Okay. So like I said, let's start at the end. Okay? We're not going to start at the beginning, which is the estate plan. We're going to go to the end, which is the post-mortem stage. And so one of the questions that was on the flyer that was put out here for this event, it says something like, what happens when I die, or what will happen to my estate after I die? And so that is what I mean by post-mortem. After you die, what happens then, right? So generally speaking, we die, and sometimes folks feel like, oh, I don't have nothing, so it's nothing gonna happen. But you will be surprised. You probably have more than what you think. You just don't count it as much. But when you really sit down to start evaluating, there is much to be dealt with, accounted for, and kind of distributed in some way or another, or administered. Okay, so what generally happens is probate. Okay, and so if you don't know what probate is, this is, now I know it may have some other meanings, right? But what we're talking about here is probate upon the passing of someone, how their estate is going to be managed, who's going to be overseeing, and how things are going to be distributed. Okay, so I'll just read this definition. It's a court supervised process of administering a deceased person's estate. The probate process includes authenticating a will, if there is a will, paying off debts by all means, and distributing assets to beneficiaries. Okay, so in that little definition, there is language there disproving a common misnomer that if you have a will, then you avoid probate. That is not true. Okay, in fact, if you have a will and only a will, you are assured probate. Okay, because in order for this will to start moving and speaking in your absence, the court supervised surrogate or actor is going to have to take a look at this document that you drafted to verify that it is really your will, your wishes, that it was signed appropriately in accordance with the state rules, and that it's an original. So if you have yours, make sure you know somebody knows where it's at, that it's kept safe. I have seen this be an issue where there were multiple wills and loved ones who were in possession or at least aware of where certain wills were that didn't work in their favor, tried or did destroy it. And so if there is no original will, most times the court is not going to honor the will and they're going to go with this other path, which is when there is a probate without a will. Okay, so if there is no will, then someone in your family, whoever is left over, will make an application to the surrogate's office, which I'm in Burlington County, so that's right here in Mount Holly, literally right across the street from the courthouse. And your loved ones will physically have to go to the surrogate's office, make an appointment, and make an application to be an administrator if there is no will. If there is a will, they take that, they validate it, and whoever you have named as your executor or executrix will then be validated and allowed to move forward and do what you want in your will. Okay. Now, in both cases, whether they're an administrator or an executor, the surrogate's office will likely require them to have what's called a probate bond. It's kind of like applying for an insurance bond, but there is some credit requirements. So I'm saying that to say that when we're making the selection of who is going to be the person who's going to be our executor, that is something to have in the back of your mind. If you're only doing a will, that this person may have to make an application to be approved for probate bond. And so you want to be mindful of how well they have managed their finances. You might not know their credit score, but you might, be able to kind of get a sense of how financially responsible this person or people are. Okay, let's talk about, and I know it's a lot of information here. I'm not gonna go through every single thing, but I just want to put it up and you can kind of look at it. So this is just talking about what happens in the state of New Jersey if you die and you don't have a will and you don't have a trust. I think this is an important foundational slide and information and a lot of facts that we a lot of times don't know. We just really don't know. We just assume that, for instance, because I'm married, I automatically know that if I were to die, that everything's going to my spouse, right? But if there is no will or there's no trust, there is no guarantee that that's the case, okay? Now, certainly if you die and you only have a spouse, then everything goes to your spouse. If you die and you have a spouse and children that are shared 100% with that spouse, then everything goes to your spouse. But then there's a million other circumstances where everything does not go to your spouse, okay? Where he or she will get a good portion, but they will not get everything, okay? So if you die with children from another relationship, that will interrupt what your spouse receives. Okay, this happens if you don't have a will or a trust. Okay, if you die with no children, a spouse and parents, then your spouse and your parents will split your estate. Now, this might sound to some people like, oh, okay, fine, no problem. But in your heart, if you have strained relationships with some of these people who you would not intend for them to actually receive any sort of inheritance from your estate, you won't be able to stop it because this is what the law says. Okay, so this is something to know. If say your spouse and your parents, or your spouse and your children from a previous relationship were already not on good terms, and you have not made any sort of clear arrangements, this is going to assure that there will be some sort of difficulty dealing with the distribution of your estate. Okay. So on and on and on. If you die and you have stepchildren, they aren't entitled to anything legally if you have not put anything in a will or a trust. And the only time stepchildren are able to receive anything, of course, is if they've been legally adopted, or if you have no other living blood from your body descendants, then they will be able to receive through intestacy. Okay. So I know that's a lot of information. Certainly, if you want to look at this chart, I can make it available to you as well. And then, of course, if you consult anything with me, you'll be able to get it as well. All right, so now that we talked about all of that, right? We've talked about some of these foundational, preliminary type or thoughts about probate. Now let's talk about the process of creating an estate plan. What are the basic things that are included in an estate plan? So I like to say basic, just we're not talking about trust yet. We're just talking about the very basic documents that you ought to have. You need all three of these, okay? So I recommend a living will, a power of attorney of some sort, and your last will and testament. All right. And these are documents that most folks, hear all the time. Sometimes they'll get them a little mixed up and confused, but it's not foreign to us. It's just that we don't really want to talk about it. Okay. Now, yes, you can go online and go to one of these .coms and print out your documents. Yes, my girl Susie, she has a box. You can just buy your box and fill out your paperwork, have a notary, do it. And so I want to say that it can be done, but can it be done well? Can it be done where you can be assured that you have addressed everything that needs to be addressed? When you do it DIY, maybe, but probably not, right? Because there are nuances and things that you may not be familiar with, and impacts of wording that are put in documents that you may not know, until it falls on your loved one, and then they have to unwind it. Okay, I know a lot of estate and probate attorneys are like, no, it's fine, let them do that, because we'll get a whole lot of fees trying to fix it for them. I don't feel that way. Okay, so I'm just saying I've heard it in these circles, but I don't feel that way. I prefer that at a minimum, even if you settle in on saying, you know what, I'm gonna research and I'm gonna do it myself. At a minimum, you need to consult with an attorney who can tell you, based on what your goals are in your specific family situation, what you should do. Okay, so of course, these are some of the reasons not to do it. There are some complex state laws. You only know what you know. You don't know what you don't know. Okay, so you may think, all right, I did everything, but there was some clause that you didn't recognize what impact it had, or you didn't recognize. For instance, I had a situation where somebody came to me after their parents passing, and they had a trust established for them that I believe their parents did through one of these online things. And they didn't recognize that in establishing this trust, that upon their child, who was an adult, their child's passing, she was going to have to essentially turn over the family property back to the state of New Jersey. This was because of how the trust was established, but they did not understand that. And so as she was preparing to do her estate planning, she really wanted to find a way to leave the home that she was living in to her children, but because of the trust that was drafted by her family, who meant well, she could not. Okay. And then this is your life and your loved ones. We don't want to halfway do it with what matters most to us. Who matters most to us? Okay. And yes, we've worked years, and we've worked hard, and we've studied hard, and we've saved money, and we've made good financial decisions, and we've established what we consider to be foundation for a good, strong legacy. And if you really want to continue on that path, you must do it. You must do estate planning, and you really should do it with the help of a professional who could think through everything with you and make sure all of your goals are achieved. Okay. All right. All right. So the living will, when we talk about this living will, this is not the same as your last will. Okay. I have seen sometimes people post things online, and they'll say, like, make sure you have your living will before you die. And I'm always like, oh no, that's not the right English, but okay. The living will is called that because this is for while you're alive. Okay, this only has power while you are here in the flesh. All right, and that's the same for a power of attorney. So you should know that upon your passing, this document and the power of attorney, they go away with you. Okay, they only live as long as you're alive. This is also known as an advanced healthcare directive, advanced directive. It may be extended, so it also has a healthcare proxy part onto it, which generally is how we do it here in my firm. We put it all together, so it's an advanced directive, and it says who your healthcare proxy, essentially establishing your healthcare power of attorney. Okay. So what we do with this document is we'll talk about what you want, what your wishes are, all of that, your healthcare wishes, your religious considerations. Do you want a feeding tube? Do you want to be resuscitated? Do you want, now since COVID, it's been a whole thing about whether you want to be put on a ventilator, right? Because before there was a larger percentage, if it was non-COVID related, to being able to come off of a ventilator. But folks, at least in the beginning of COVID, when they were being put on ventilators, they weren't coming off in large numbers. Right? So those are things that are addressed in your living will, as well as whether or not you wish to be a donor of any sort. Okay, so I know we're coming in on time, so I'm gonna speed through. Okay, then we have power of attorney. This is a document that authorizes somebody else to stand in for you. Why is this important? A lot of times things will, like we talked about in the beginning, changes will happen. It could be something, a sickness. It can be an accident. It could just be genetic, mental decline that happens in families sometimes, right? Or happens in old age. And if there's no power of attorney in place and capacity is completely lost, the only other path forward is guardianship, which can be expensive. It can possibly be lengthy. It's not necessary though, if you have a power of attorney in place, okay? So you pick someone who you trust and you say, hey, in the event that I can't, or I don't want to act on my own, you are able to step fully into that position for me, okay? And there are springing and durable. This is important because when people hear, oh, I'm going to give somebody power of attorney, meaning they can go to my bank and they can make decisions on my behalf and they can sign for me and all that. I'm not comfortable with that. While I have my complete capacity, no problem. You can establish a power of attorney that's called a springing power of attorney. This means it'll only come into effect upon incapacity, okay? So it's not going to happen immediately. And then there are those that are probably more common, which is the durable power of attorney, immediately goes into effect upon signing. Also, very, very important, both documents are freely revocable. You can wake up the next morning and say, I did what? And rip it up, and that's it, it's done, okay? All right, so this is just some extra information about power of attorneys. Some banks and government agencies have their own form. Most of your attorneys, me for sure, us here in my office, we will take that document and use that document in addition to your other power of attorney so that you have that. Or if specific language needs to be in your power of attorney, we will make sure that's in there, okay? And then this document everybody knows about, last will and testament. And people are like, oh, I don't need that because I don't have no money. But it's not just about money, right? And again, you might be surprised what you actually do have, especially if things are going to be liquidated and you might be a homeowner or you own some jewelry that you've collected or I don't know, shoes or bags or whatever. These amount to some value, okay? But it's not just about money. It's about you can decide things about your burial, how you want bills paid. For instance, if you have life insurance, yes, it pays straight out to whoever you said it's supposed to go to. But you might say, before you spend all of your insurance proceeds on shopping, I want my bills paid first, okay? Again, marriage is not the only reason, is not really a reason at all to not get a will. Even if you're married, you should have one. And in that case, if spouses are getting them done together, in my office, we don't do one will for spouses. We do what we call mutual or reciprocal wills, which are largely the same document. They pretty much mirror. There may be some changes, but it's much easier at the time of probate to do it that way, okay? All right, so moving on. Now, I just want to touch on this because a lot of times people want to know, what is a trust? What's the difference between having a trust and having a will? Well, a trust is the document that can actually help you avoid probate altogether if it's done correctly, okay? This is an agreement. So it's just, some paper that you put in agreement, you as the settlor or the grantor, that's the person who's establishing it, saying, I want this person or these people to be the trustee of these assets that I'm placing in this trust, okay? For the benefit of, and it can be for your children, it can be for your spouse, it can be for a charity, however you want to do that. And then we title whatever those assets are to your trust. We can open up, generally speaking, once we do this trust agreement, you will open up the bank account. So if you have any sort of liquid assets, they will go into the bank account. You can put your home in the name of your trust. You do this just by adding the name of your trust to your deed. If you're doing a living, well, there's a whole lot more to that, but it's as simple as doing a new deed and making your trust the owner or co-owner of your properties, okay? And you can also make your trust the beneficiary of your life insurance or any other financial accounts that you have that will otherwise pay out to your beneficiaries. You can make your trust the beneficiary, okay? And there are, generally speaking, two types of trust, revocable and irrevocable. Now, in there are probably about 10 to 20 other types of trust, but the overarching types are revocable and irrevocable, okay? And they are exactly as they sound. Revocable means that while you are living, if you have established this trust, you can change it, you can terminate it, you can do whatever you want. And those things that are in the trust still count as a part of your estate, okay, until you pass away. Irrevocable trust is the opposite. It's you really can't change it, but if you change it, you have to go through a process. So all the beneficiaries have to be in agreement, or you have to get a court to say you can change it, okay? It's much more difficult. And you will have a tax ID number for your irrevocable trust, okay? Now, a lot of people pick it because it moves things out of their estate. And if they think, you know, I might make an application to Medicaid for long-term care, right? This is a way to avoid having to spend down your assets or to sell your home. So long as it's been 5 years from when you put it in your trust to when you make a Medicaid application, it won't count against you. I know it's a lot of information, but that's really one of the biggies, okay? So I have that discussion a lot around trust and why someone might select to do an irrevocable trust to move things completely out of their estate. It will not count against them, and for Medicaid purposes after 5 years. Okay, so we pretty much already talked about this. Now I will say New Jersey presumes that when you establish a trust, it's revocable. So this is another reason why you want to have a professional assist with this, because you just want to make sure that the language is correct. Because even if you had the intention to establish an irrevocable trust, if it's not worded correctly, the state says no, that's not, no, we don't see it that way. And so that still counts as a part of your estate, which is not what we're wanting, right? If we're going for an irrevocable trust to help avoid creditor, you know, to give creditor protection or to keep or preserve Medicaid or other government benefit eligibility. Okay. All right. Last consideration, and then we're gonna move into questions and answers. So as an attorney, this is definitely something that's always in the forefront of my mind when we're dealing with estate planning. Many times I have folks who are caregivers either contact me about establishing an estate plan for the person or persons that they are giving care to. A lot of times it's adult children who are trying to help with their parents. This is all good, and generally speaking, with well intentions or well-meaning. However, I'm still always aware, because sometimes people will make decisions because they feel like they have to. And sometimes you as the caregiver or the adult child may say nothing, but your presence alone can cause undue influence sometimes, right? So a lot of times when I have folks in my office or on the phone, I will try to have a few moments alone with who we call the testator. This is the person who is establishing their estate plan, just to be sure that they understand what they're doing, that they're doing it of their free will, that there is no duress. And as folks are aging, sometimes I've noticed that they will be sharp for moments, and then a few minutes later, not quite sure, a little bit confused. So these are things that that you should be aware of as caregivers. And you should also be aware that attorneys are going to be watching for that. So what you can do, and I love when this happens, when adult children bring their parents and they say to me, you know, like, you can talk to them by themselves. Please talk to them by themselves. You know, take them in the conference room without me, or call them without me, please, by all means. It just helps me to not have to feel like, you know, I'm making everybody uncomfortable, because I'm going to. But I would prefer if we can be partners in it, and not just me, but I'm sure all attorneys feel this way, because we are going to be held to the fire, so to speak, if a will or some other document is challenged down the line, right? Because the court is going to look at us as officers of the court to say, were you sure that this person wasn't under an undue influence or had complete mental capacity and understanding of what they were doing and the will to do so? So that is just something to just put out there for you to be thinking about, and to know, like, so when you're establishing a power of attorney, a living will, and a will, but the power of attorney and living will, this happens a lot. It has to be the person who is giving the power of attorney. Okay, they have to establish it, because I have had adult children call and say, I'm calling because I need you to do a power of attorney, making me power of attorney for my parent. And I always have to say, just know that I need to have a conversation with the person who is establishing this power of attorney. It doesn't work that way. Okay, all right, I spent a lot of time on that, but I want to make sure we understand. So this is probably what's in the back or in the front of everybody's mind, which is, how much is it going to cost me, right? I don't know what that is. I don't know if I did that. Okay. But let me just ask you a question first, and just so anybody who's watching time, I only have, I think, one more slide. How much will it cost me? So I have to ask you back. Since you asked me, how much will it cost you? I have to ask you back. What is it worth to you? What is it worth for your family to possibly eliminate probate, or if they were going to have to go through probate, to reduce or eliminate confusion, heartache? If you've always been the protector, if you've always been the peacemaker, what is it worth to you to be able to do that even in your death, even in your absence, right? Most people are going to say it's priceless, right? I can't put a number to it. If you really think about what you resolve by planning in advance, it's probably priceless. Okay. But now I know you're like, yeah, what are the numbers, right? So let me say this. I don't really 100% know, because there isn't like, we're not allowed as attorneys to have a meeting and say, hey, everybody, this is what we're pricing, right? Or, you know, let's try to make sure that everybody's paying this, that. So I'm giving you a large range of what it may cost you, but this is no like guarantee. Okay. And my firm falls within the range. Okay. So I am saying that. So generally speaking, for documents individually, so if you were just going to say, oh, I just want a power of attorney, or I just want a will, that's it. They generally range, if professionally prepared, from $500 to, I would say, like around $1,500. Okay. And of course that would depend on who, you know, the professional, how complicated the matter or the document, but that's generally speaking. Now, trust, that's completely different, because they are usually much more complicated. The language has to be very specific, and your goals, all those sorts of things, how long you want the trust to be for. Trust can last for generations. So you can establish a trust today, and it can be governing your family and your assets for generations to come. You know, so those wishes would be, of course, up to you and whatever you may have, whatever you want to distribute. And you would be surprised. I've seen a lot of younger families and couples who are like involved in a lot of real estate, who are wanting to establish these trusts to make sure that things are distributed the way they want in the event something happens to them, and especially if they have like young children, that sort of thing. So I've been really pleasantly surprised to be contacted by a lot of folks about that. Okay, so they can range anywhere, I guess, from like $3,500 to $15,000, and it could probably even go up from there. I was recently speaking to a Medicaid attorney. She does elder law and she does Medicaid, and she was saying, you know, I do the applications to Medicaid, and most times my clients are, you know, having to establish trust, and they're paying around $10,000 for these irrevocable trusts. So we don't charge that yet in my firm, but I understand why they would be. Okay. And estate plans in general, would range, and by that I mean just either having just the first three documents we talked about, a living will, power of attorney, and a last will and testament, to $20,000, which would include trusts and all those documents. And most times it would include a couple's package of some sort. Okay. So this is just kind of to put some numbers in your mind, but it's not a hard, fast rule. It will range from attorney to attorney or service to service. Okay. And then just a reminder that if you already have an estate plan, that you should review them probably every, I would say 3 to 5 years, just to do a review, and or if there's any major changes in your life. Okay, so that is if the passing of someone, or the birth of someone, any new assets that you may have acquired, those may be triggers for doing a new estate plan. I'm sorry about whatever the scribble is there. I don't think I did that, but I'm sorry. Okay, so you can find me at Bettner Gray Law Office. I'm in Mount Holly, New Jersey on High Street, 115 High Street. And there is my website and all of our info, but I know that they're gonna provide you with that link and everything later. So my last slide is for questions. So I'd be happy to take your questions. And I actually could stop my share, I think.
Hi, Chandra. Yes, there are a few questions in the chat.
Okay,
So-
wonderful.
Okay, the first question is, will this information be available?
I will happily make it available. I'm trying to figure out how to turn off my share, but I can't figure it out. Yes, I will happily make this available. If you would like, I guess I can do it as an outline of the slides, and I will make that available to the ladies here of Delta. And then if that's okay, and you guys are able to distribute it however you like. Okay.
Okay. The next question, I think you spoke on this. Can you speak about revocable living trust? And
Yes.
I did-
So let me say this about the revocable trust. While I do them all the time, I especially do them for like younger folks who know they want to do an estate plan, but they're not sure of whether they're of a lot of things. If they're going to be having more children, if they are going to be purchasing more properties, but they know they want to establish a trust. So I recommend a lot of times that they establish a revocable living trust. So what it does is we still do all of the same things as we would do with the irrevocable trust in terms of the documentation, right? We draft up what their wishes are, who they want to be a trustee, who is for the benefit of, how they want things distributed. But while they're living, they can make any changes that they want to it, okay? But when they pass away, it becomes irrevocable, meaning it cannot be changed at that point, which is really the power, which is why it's still worthwhile, right? Because while you're living, you're not sure of everything, but you can be sure that your intentions will still be carried out, and probate will still be avoided upon your passing because now it's irrevocable. So how probate is avoided is if you have a trust, your trustee, as soon as you pass away, can start doing what you've told them to do. They don't have to be bonded. They don't have to go to the probate. They don't have to go to the surrogate court to go through probate. Okay. I've seen it happen, and it's amazing. I established a trust for a woman she was aging, but she was also ill. She had 3 adult children, and she knew clearly what she wanted to do. I helped her sell her home. She put all the proceeds in the trust. And then she passed, I would say probably within 90 days after we established that. And her trustee could then immediately start distributing those funds that were put in the trust account. There was no waiting period. And when that was important because one of the adult siblings had gotten a foreclosure notice, and she needed a significant, small amount, but it was significant to her. She didn't have it. And the trustee was able to called me and said, am I able to do anything? I said, you sure can. You can go right now and get that money and give it to her to help her out. So there's some power in the trust. We want to run a lot of times from it, but the reason, there's a little bit of a upfront investment is because what it does on the back end is quite powerful.
Okay. And the next question, is this information, can you give additional information for other states such as Maryland?
So I really cannot, although I will say Estate planning in every state in the United States is very similar, right? So the law itself, generally speaking, is similar. But from state to state, there are specific things that you would need a specific attorney in that state, I would recommend. Now, there's been times where I've had folks come here from other states, and I will partner with an attorney in that state, or in the alternative, I have people who live here, but have properties in other states, in which case I'll partner with the other attorney. I don't want to, I never want to steer anybody wrong. So I listen in my consultation. If it seems to me that this is going to need the expertise of someone in another state, then I will absolutely refer or partner with them.
Okay. And this, I believe you answered this. What is the difference between a trust and a will? You did.
Yeah,
go over
that's
that
really what it
information.
is. Yeah.
Yep. And the other question, can you make the chart available? But you were going to.
Oh,
give us-
yes. Yep, I'll give it to you.
Okay. What if a parent dies with a mortgage or auto loan and both assets are titled to a trust? Does beneficiary have to go through probate?
No probate. If it's properly, now let me just say this, if it's properly titled to the trust, probate is avoided altogether. Whoever the trustee is can get working right away to do whatever needs to be done. So if there's assets in the trust and that mortgage can be paid off, by all means, they can do that. A lot of times there are not assets available in the trust. Sometimes there is, but a lot of times there's not, in which case decisions have to be made. So you may want to consult with an attorney to decide, are you keeping the property? Do you want to sell it? How are we dealing with this mortgage? Is it one beneficiary of the trust, or are there multiple siblings that are all equal beneficiaries, right? So all of those things are going to impact what happens, but probate is avoided if those things were properly titled to the trust. There's no need to involve the surrogate court.
Okay. Do you administer RLT?
Revocable living trust?
Yes.
Yes.
Okay.
Yes, we do. We help establish them, and then by all means, we will help with administration on the probate side if and when that's, if a family comes to me for that, by all means, we help with that. But the truth is, like, a trust should be very clear, and it shouldn't be a lot of confusion about what to do next. Although sometimes a trustee may just be overwhelmed and might need a little bit of advisement about how to carry it out. But if it's drafted right and those instructions are clear in there, the trustee can just start doing what they're supposed to do.
Okay. And the last question is kind of a two-part. My father is under Medicaid and in a nursing home. Is it best to establish POA or guardianship?
Yes, what it'll depend on is capacity. So if your father is completely with it and understands and wishes to make you his power of attorney, then you can go that path by all means. But if there's any question in his ability to understand, appreciate what he is doing by signing the documents, then you are going to have to do guardianship. I think, yeah. I saw a question that was in the forefront of my mind pop up.
Okay, and the other part of that was, I did POA prior to my mother passing, but it expired after her death, and there are a few unresolved issues. I solved several as an executrix, but I'm not sure how to solve what's unresolved.
You absolutely need to probably consult with a probate attorney by all means. If you're in the state of New Jersey, I'd be happy to consult with you. If you're an executrix, then you have the power to resolve whatever those issues are, but you may need help. So I help executors and executrixes all the time because sometimes it's just overwhelming. Sometimes it just seems jumbled up. So certainly you can consult with me or another attorney. But if you are an executor, you already have the authority to resolve it.
Okay, and there's a question, and he can come off of mute, Marvin. And then
Okay,
after
great.
Marvin, I have one more question for you.
Yeah,
Okay.
I just wanted, I'm seriously interested in the irrevocable or revocable living trust. So I just wanted to put your contact information back up because I didn't get a chance to write down the
Oh, okay.
information.
I can also, I think they're gonna put it in the chat.
Yes.
Okay, they have like the website, which is BettnerGrayLaw.com. If you go to my website, you'll see all of my contact information there. So that's the quickest way probably to do it. I'm also on Facebook, Bettner Gray Law, and Instagram, and all the things. They tried to put me on TikTok, but I didn't do, I can't do the TikTok, y'all. But you can find me on there, but I'm not achieving much, I don't think. I think I
Okay,
did see, oh, okay, there's
Yeah,
one more.
there's something for question for clarification. Do you only go to probate if the last will and testament is unclear?
So I'm sorry if I confused you, because that's not correct. Probate, if there's a will and there is no trust, there's just a will, you will go to probate. It is, all wills go to probate. And the reason for that is to verify that that is a legitimate will, to make sure that nobody who is supposed to be notified is left out, for there to be accountability. And then again, as I mentioned, they may have to be bonded. So every will goes to probate. The only way around that is if there is also a trust that the will essentially points to, and the trust takes care of everything. All right. I do a will for my clients as well as a trust. And the reason for that is just in case we miss something. So in case we forgot to put something in the trust, or in case something new is acquired later and we didn't get a chance to catch it and put it in the trust, I say in the wills, essentially, anything that was not already addressed in my, or title to my trust, is to what we call pour over from my, through my will into my trust, okay? But if there's only a will, there will be probate. All right, so the only way to avoid that is so there's two ways. There's the low grade way, which is to put somebody else's name on all your stuff. And I know that not everybody loves that. I've mentioned this before, and people are like, I'm not putting their name on my bank account. I'm not putting them on my deed. So that is a way, that's what I call like a low grade way to do it, okay? But it can be done. So if you put somebody's name on your deed, on all your bank accounts, and on your life insurance, then, and on your car and everything you own, and if somebody else owns it with you as joint tenants or as co-owners, then those things avoid probate, okay? But if there's things that you own by yourself, bank accounts and all that, and you don't have a pay on death beneficiary name, it will have to, all that stuff is going to have to be probated one way or the other, whether you have a will or not. I hope I cleared that up.
I think that was all the questions. And just for the attendees, there is a link, and you will be given a consultation. You'll be available after the presentation.
Mhm.
So
yeah, so we normally, I normally offer consultations for $250. And the reason I charge, when I started, I didn't charge, but the reason I charge is just to kind of make sure that folks really are really interested and may possibly retain. But I also credit that to people. But that doesn't apply to you because you have been here with us, because you registered. I think we reduced it to like $50. So everybody that's attending here, even y'all folks on Facebook who I don't think y'all register, but the link is there, right? I think they can see that, and I will
Yes, it is
happily consult with you. And for me, you just getting the information is a win, whether you proceed or not. That's all.
okay, yep, that's all the questions. And everyone it just appears the next thing is that they loved it and they appreciate this information. Thank you.
Thank you so much. Thank you for having me.
Wow, it's a lot of information. Thank you. Thank you so much, Ms. Bettner Gray, for all the useful information that you presented this evening. Participants, here's your time to let us know how you received this session and what else you may want the chapter to present. So I'm going to place that link in the chat. And if you can, before we leave after the closing, if you can just access that link just for a few moments, just to give us some feedback regarding tonight's session. Thank you. Paul Ashley.
Yes, so thank you all so much, for your attendance, for paying attention, for the great question and answers. To our guest speaker, the esteemed Chandra Bettner Gray, that was such good information for all of us. We've all seen over the years celebrities, whether it's Prince, Aretha Franklin, all of these people who everybody was shocked that, they didn't have the proper documents in place. And, even though we might have the size of states that they've had, it's still important for us to have those same protections in place. So just, I want to thank everybody for the participation on behalf of myself and my fraternity brothers of the esteemed men of Alpha Phi Alpha Fraternity Incorporated, the Trenton-based Zeta Iota Lambda chapter. I want to thank you all for attending, and I want to thank the Deltas for allowing us to co-sponsor this event with them. So with that, I want to hand it over to Madam President of the Trenton Alumni Chapter of Delta Sigma Theta Sorority Incorporated, President Georgette Bowman.
Thank you, Paul, and thank you all for attending our partnership this evening and our speaker series this evening. And another name to throw out is James Brown. That was another person, I think, with an issue with their will. So again, we think of all of these stars, but we have to think more on our level, the smaller people. And we need to also establish that we need to have a will as well. Again, thank you to our presenter, and thank you to our audience for attending this evening. And I would like to thank the gentlemen of Alpha Phi Alpha Fraternity for partnering with us, collaborating with us. We appreciate you and your support. I would like to thank our Economic Development Committee, the chair, co-chair, Nicole Carmichael, Janelle Hazel, their committee. I would like to thank our technology team in this day and age. We greatly appreciate their support, and we ask that you remember to complete the evaluation, and we look forward to seeing you on our next speaker series. Good night, everyone.